Welcome to the Am I Free to Go podcast, where the Constitution isn't just paper, it's ammo. I'm your host, Soundrone with Soundbite News Media. And here, we don't just talk about your rights, we lock, load, and defend them. We expose censorship, spotlight real amendment battles, and bring you the stories the mainstream's too scared to touch. So, whether you're behind a mic, behind a badge, or behind enemy lines on social media, this is your front line in the fight for free speech. Strap in, speak up, and never ask permission, because around here, we know the truth. You are free to go. Episode 004, Understanding Trespass and Public Access Rights. In this episode, we break down the basics of trespassing, what it is, how it happens, and why it matters. Trespass means entering or staying on private property without permission. And yes, even by accident, it can get you fined or arrested. We'll also talk about the difference between civil and criminal trespass, and how intent plays a role. Plus, we'll start looking at how public property is treated differently, especially for auditors and activists.
Welcome to the deep dive. Today, we're plunging into something most of us think we get: trespass. You know, the whole stay off my lawn thing.
Right.
But our stack of sources covering legal definitions, property management tips, the sometimes wild world of journalism, and even a pretty controversial social movement reveals just how layered this concept really is. It's surprisingly complex.
Absolutely. It's definitely more than just physically being somewhere. We're looking at what it truly means to be on someone's property without permission, how consent isn't always a simple yes or no, and how this seemingly basic legal idea bumps up against things like free speech and the right to gather news.
So our mission for this deep dive is to untangle those layers. You know, who actually counts as a trespasser? What power does a property owner really have? When does it go from a simple mistake to a criminal offense? And how do we make sense of it in those messy modern scenarios, like people filming in public spaces?
Exactly.
Yeah.
We'll break down the core legal ideas, walk through what property owners need to know, look at how journalists can sometimes inadvertently trespass, and dive into the legal tightrope walked by those folks conducting First Amendment audits.
Okay, let's unpack this then, starting with the fundamental question. What does the law actually mean by trespass?
Well, at its heart, trespass is defined as entering or remaining on someone else's property without their consent. Our sources emphasize this isn't just limited to, say, buildings.
Right.
It includes things like driveways, fenced yards, or even just stepping onto land that isn't yours without permission. It's fundamentally an intrusion upon the property owner's right to exclusive control.
And it's not just about someone sneaking onto your property, is it? One detail from the sources that stood out to me is that someone who was initially invited, a guest, can actually become a trespasser if they refuse to leave after the owner asks them to.
That's a really key point. Consent isn't permanent. It can be withdrawn. And once it is, any continued presence on the property can absolutely constitute trespass.
Okay. Now, is trespass always just, a matter for civil court? Like getting sued for damages or something? Or can it be more serious?
That's where the complexity really starts to show. Trespass can be a civil tort, a criminal offense, or sometimes even both. It depends heavily on the jurisdiction and the specific actions involved.
So civil first.
Right. Civil trespass, as one source explains it, is basically an intrusion on property rights that gives the owner grounds to sue.
And you said earlier it doesn't always require actual physical entry. That feels a bit counterintuitive.
It does, doesn't it? But civil trespass isn't solely about your physical body being there. Setting in motion a force that enters and damages property, like the example given was channeling polluted water onto someone's land, they can be considered civil trespass because it interferes with their property rights.
Okay, so civil is about the interference with the rights, even indirectly. What makes it tip over into criminal trespass?
Criminal trespass involves knowingly and unlawfully entering or remaining on property. The stakes are higher here. You could be looking at fines or even jail time. And the details matter a lot.
Like what kind of details?
Well, a Colorado source breaks it down into degrees. First degree might involve unlawfully entering someone's home, or maybe their car, with the intent to commit another crime inside.
Okay.
Second degree could be entering, say, a fenced yard, or an enclosed area, but without that extra criminal intent. And third degree might just be being on unenclosed private land without permission. So the type of property and the intent behind the intrusion significantly affect how serious it is considered.
So the simple act of being somewhere you shouldn't becomes a crime when you know you shouldn't be there. And the level of crime depends on where you are and maybe what you're planning to do.
Pretty much, yeah.
What other core elements do the sources say define trespass in U.S. law?
Well, beyond the unlawful intrusion itself, the sources highlight the element of intent regarding the intrusion. This is subtle, though. It means the act of entering or remaining was intentional, even if the person didn't specifically intend to trespass or cause harm. So, stepping onto land, even if you genuinely but mistakenly thought it was public or yours, often still meets the intent requirement for trespass liability. Good faith or a mistaken belief isn't always a get-out-of-jail-free card.
Wow.
Though some places do have an innocent trespasser rule, which offers some protection if the entry was completely unintentional and, crucially, no harm resulted.
That's a critical nuance. It's the intent to take the step, not necessarily the intent to break the law by taking it.
Exactly. Another element sometimes considered is force, especially if the trespass is a direct result of force used by the person entering, and then there's consequent injury.
Damage, basically.
Well, yes, actual damage to the property can be part of a claim. But the sources make it clear that the unauthorized intrusion itself can be considered a form of injury in the eyes of the law. Intentionally entering someone's land without consent can make you liable as a trespasser, regardless of whether you physically harmed anything.
So the violation of the property right is the actionable injury in itself. Okay. You mentioned consent earlier. What about times when permission isn't explicitly granted, but maybe implied?
Yes, implied consent. A source from WEX defines this as agreement that's not stated directly, but you can infer it from actions, inaction, or just the surrounding circumstances and customs.
Like walking up to someone's door.
Exactly, like walking up the path to someone's front door to knock you.
Yeah.
Generally have the implied consent to do that, unless there's a clear sign saying no trespassing, or a locked gate telling you otherwise.
We're going into a shop?
Right. When you walk into a store during business hours, you have implied consent to be in the areas open to the public for the purpose of shopping. But if you wander into an area marked employees only,
You've gone too far.
you've exceeded that implied consent. It's often used as a defense in trespass cases. If a reasonable person would assume they had permission based on the situation, or maybe if the owner didn't object when they clearly could have, consent might be implied.
Okay, that clarifies that. It's about reasonable assumptions based on the context. So, flipping the script now, what do the sources say about what a property owner should actually do if they find someone trespassing?
The property management source gives some pretty practical advice here. First, look for signs someone is there without permission. Are they in restricted areas, ignoring signs, acting suspiciously?
Makes sense.
If you suspect trespass, your absolute first priority is safety. If you feel threatened or the person seems dangerous or unpredictable, don't hesitate, call law enforcement immediately.
Okay, but what if there's no immediate sense of danger? Can you just tell them to get lost?
You absolutely should. You should clearly and, if possible, kindly inform them that they're unwelcome and ask them to leave. This can be verbal. If it's a recurring issue, maybe written notice or just prominent signage helps establish that.
And tell them what happens if they don't leave.
Yes, it's wise to inform them of the potential consequences if they don't comply. But this is where knowing your local laws is absolutely critical. The sources strongly advise consulting a lawyer or perhaps a property management company.
Why is that?
Because mistakes in how you handle it can actually create bigger legal problems for you, the owner.
So it sounds like it's not just about asserting your right to the property. There's a specific legal dance you might have to perform.
That's a good way to put it. If they refuse to leave after being asked, you might need to follow a specific legal process to have them removed. It's different from a standard tenant eviction, but it still involves formal steps.
And what about force? Can you physically remove someone?
Critically, understanding your state's self-defense laws is paramount here. The sources are very clear. You generally cannot use deadly force against a simple trespasser. You can only use necessary reasonable force.
What's reasonable?
Well, the general guideline is to start verbal. Physical restraint, like maybe gently ushering them towards the exit, is usually only advised if it's clearly safe to do so, there's no threat of violence, and you can disengage immediately if things escalate.
And if they get aggressive?
If the trespasser becomes aggressive or threatens violence, Your safest and legally soundest option is to back off, disengage, and call the police. Let them handle it.
Safety first, legal process second. It sounds like letting the professionals handle potential confrontation is the consistent advice.
It really is. Hiring a property manager, or at least consulting an attorney, helps ensure you're following the specific legal requirements in your area, which can prevent costly mistakes down the line.
All right, we've covered the basics and the property owner's perspective. Now let's step into some specific, often quite controversial areas where trespass becomes incredibly relevant. News gathering and this phenomenon known as First Amendment audits. These aren't just simple cases of someone, accidentally wandering onto your lawn.
Precisely. In these contexts, the definition of trespass bumps right up against constitutional rights and very different intentions for being on the property in the first place. Starting with news gathering.
Right.
Journalists aren't exempt from trespass laws just because they're chasing a story. The sources on news gathering torts highlight several ways they can run into trouble.
Like the obvious ones, just walking onto private property without permission, or maybe staying after being asked to leave.
Right. Those are straightforward.
Yeah.
But it also includes exceeding the scope of the consent they were given. So, if a reporter is invited into a business's public lobby, but then they wander into a back office clearly marked employees only, that can be trespass, even if they were initially allowed in the building.
And wasn't there a really big case about this, where journalists actually got jobs just to film inside a company?
Yes, that's the famous Food Lion case.
Yeah.
Reporters got hired by the grocery store chain using false information on their job applications, specifically to get access to non-public areas with hidden cameras.
And the court said?
The court found that entering the property under those false pretenses, even though they were technically allowed in as employees, constituted trespass because the consent, the permission to be there, was obtained fraudulently.
Wow. So lying to get access, even if it's for what you believe is a legitimate news story, can completely negate the consent and lead straight to a trespass claim. What about the digital world? Does that count?
The sources do mention virtual trespass. This refers to unauthorized access in non-physical ways. Think like accessing private voicemail messages or entering closed sections of a website using an unauthorized code, maybe bypassing digital security to get information. It's the same basic principle of unauthorized intrusion, just applied to electronic space instead of physical land.
So it's not just physical space, but even misleading someone to get access or unauthorized digital entry can be seen as trespass for a journalist. That's complex.
It is. The method used to obtain the information gets highly scrutinized. Honesty about your purpose is crucial, and if that purpose changes midway, they really should seek renewed consent. And the basic rule remains: if a property owner asks you to leave, you must leave, and quickly, to avoid a trespass claim.
Okay. Beyond trespass itself, the sources on news gathering mention other related legal issues, other torts that journalists face. What else should we be aware of?
Yeah, a major one is recording without consent. This gets incredibly tricky because state laws vary wildly on this.
How so?
Some states require everyone involved in a conversation to consent to being recorded that's all-party consent. Some require two parties, and some only require one person involved to know about the recording that's one-party consent.
That sounds like a minefield if you're dealing with people in different states.
Exactly. If you're recording a phone call or an interaction involving people in multiple states, figuring out which state's law applies is complex. The best practice advice is often to just follow the most restrictive state law involved, or better yet, simply get explicit consent from everyone being recorded.
That definitely sounds like the safest approach. What about privacy itself, beyond just recording?
Invasion of privacy and disclosure of private facts are also significant risks. Intrusion can happen if the news gathering methods themselves are highly offensive to a reasonable person, even if they occur in a place that's sort of public.
Can you give an example?
The Sherman v. Group W Productions case is often cited. A reporter filmed the rescue of an accident victim, including recording conversations inside the medical helicopter transporting her. While the accident scene itself was public, the court suggested that filming inside the helicopter during medical treatment could be an invasion of privacy, because there's a reasonable expectation of privacy in that specific situation, regardless of the helicopter's location over public roads. It highlights that the method and the specific location within a broader location really matter.
So even if you're in a generally public place, like on a highway, certain specific moments or enclosed areas within it might still carry an expectation of privacy.
Absolutely, especially with technology like hidden cameras or powerful telephoto lenses or drones. Using those to film someone, say, in a bathroom or changing room or a hospital room, even if the camera itself is technically on public property looking in, raises huge privacy concerns. Some state laws specifically prohibit cameras in private places like that.
And I suppose anti-harassment laws could also potentially apply if someone feels like they're being filmed repeatedly or aggressively.
Yes, though the sources note, these laws can sometimes clash with First Amendment protections for news gathering. As a constant balancing act the courts have to perform between the public's right to know and individual rights to privacy and not be harassed.
Right.
And finally, there's the issue of publishing illegally obtained information. Generally, the law protects journalists who publish information that was obtained illegally by someone else, a third party.
As long as the journalist wasn't involved.
Right, provided the journalist didn't participate in or encourage the illegal act, and the information itself is a matter of public interest. The Supreme Court case, Bartnicki v. Vopper, is a key example there, involving illegally intercepted phone calls.
But if the journalist was involved?
Then it could face liability. If they prompted it or paid for it or were directly involved in the illegal activity to get the info, that's different. And publishing certain types of very sensitive non-public information, like medical records, carries extremely high scrutiny, as seen in that Pierre Poll v. ESPN Inc. case.
It really sounds like news gathering requires constant awareness of all these invisible legal lines: physical, digital, and ethical. Now, let's shift gears to that more recent phenomenon that brings trespass and filming into sharp public focus: First Amendment audits. What exactly are these, and why are they so contentious?
Right. First Amendment audits, according to the sources, are essentially a social movement where individuals go around filming or photographing in public spaces and publicly accessible areas. Think sidewalks, parks, maybe the lobbies or exteriors of government buildings.
And the goal is?
The stated goal is often to test their constitutional rights, particularly the right to film in public. Auditors often see themselves as citizen journalists or activists promoting transparency and accountability by filming public officials or government property. They believe they have a First Amendment right to record, and importantly, courts in many federal circuits have affirmed a qualified right to record in public spaces where there's no reasonable expectation of privacy.
Okay, so there is a recognized right there. But the sources also mention critics calling them frauditors. What's the basis for the controversy?
Well, critics, as described in the sources, often point to what they see as confrontational tactics, maybe aggressive behavior, refusing to identify themselves when asked, sometimes using insults, and maybe a perceived profit motive from posting the videos online. Some auditors are also associated with sovereign citizen ideologies, which adds another layer.
So the legal right to film in public exists, but like most rights, it's not unlimited, right? Where does it run into boundaries?
Crucially, yes, the right to film in public is subject to reasonable time, place, and manner restrictions. And this is exactly where it directly intersects with trespass law.
How so?
Protections for filming do not override laws against trespassing on public or private property. They don't give you the right to enter restricted areas, like a crime scene, or to materially interfere with official duties, like police work.
And that seems to be where the confrontations often happen, when filming bumps up against property lines or official business.
Exactly. You might have property owners or building managers objecting to filming, especially inside buildings, even public ones. Auditors often refuse to start filming or refuse to identify themselves. Police get called.
And the arrests aren't usually for filming itself?
Often not, no. While the act of filming might be protected in that location, the confrontations frequently lead to arrests for related charges. Things like obstruction of governmental operations, disorderly conduct, loitering, defiant trespass if they refuse to leave private property, or failure to identify themselves if required by state law in that context. The sources note that convictions for these related charges stemming from audits are actually frequently upheld on appeal.
So the arrest isn't technically for filming, but for something that happened while filming, often relating to property access rules or how they interacted with officials.
That's the critical distinction, yes. The right to film doesn't grant immunity from other laws. It doesn't give you the right to be anywhere you want or to ignore lawful orders, like in order to leave private property or to stop interfering with police activity.
Is there a key case on this?
The sources highlight a significant recent case, United States v. Christopher J. Cordova. He was actually convicted for filming on federal property without specific agency permission. The charges were failure to comply with lawful regulations and unlawful photography on government property. His appeal was denied, reinforcing the principle that even on government property, the controlling agency can set reasonable restrictions on access and activities, including filming, and require their permission.
That's a very strong reminder that public property doesn't automatically mean unlimited access for absolutely every activity, including filming inside facilities.
It really is. And the sources also mention the Hoyt Webb case, which unfortunately shows how quickly these situations can escalate dangerously. That involved an auditor who ended up at a physical confrontation and was charged with assault, with his own recording used as key evidence against him.
So even things like just insulting an officer, where does that fall?
Well, simply insulting police is often protected speech under the First Amendment. However, if the insult or behavior crossed the line into actively interfering with your duties or causing a public disturbance, it can sometimes lead to charges like disorderly conduct or obstruction. But just voicing criticism from a non-interfering distance usually isn't enough.
Okay, so to sum up this part, while the act of filming in public itself is often protected, the context, the specific location, public versus private, restricted versus open, the behavior of the person filming, and their response to lawful requests or orders are what can turn a First Amendment audit into a legal problem, frequently involving trespass or those related charges.
That captures it very well. It's a clear example of how trespass law and related public order laws act as a boundary, even when other important rights like free speech and the right to record are being exercised.
It's really fascinating how one's sort of basic concept, trespass, branches out into so many different legal areas in modern conflicts. Just to widen our view for a moment, how does another legal system, say English law, approach trespass? Is it similar?
The sources touch on this briefly. They note that in England and Wales, trespass is primarily seen as a civil tort, much like our initial definition of civil trespass here.
So mostly suing, not criminal charges.
Generally, yes. While it can be a criminal offense, that's usually reserved for very specific circumstances, like trespassing on railway property where safety is a major concern. English law traditionally categorizes trespass into three main types: trespass to the person, which includes things like assault, battery, false imprisonment, trespass to goods, and trespass to land.
And trespass to land there is actionable per se, I think the term was. What does that mean?
Yes, actionable per se. That basically means you generally don't have to prove that actual damage occurred to the land to bring a successful civil claim. The unauthorized intrusion onto land that's in someone else's possession is considered an injury in itself, whether that intrusion was intentional, negligent, or even purely accidental in some cases.
So maybe a slightly lower bar for a civil claim there compared to needing knowing entry for criminal trespass here.
It points to a slightly different emphasis, yes. Compared to the U.S. system, where criminal trespass is quite common and often hinges on whether the person knew they weren't supposed to be there, it just shows how the same fundamental idea, interfering with property rights, can be structured and weighted differently under different legal traditions.
Okay, so bringing this all together, what does all of this mean for you, our listener, as you just, navigate the world day to day?
Well, understanding these nuances of trespass is surprisingly relevant, I think. Whether you happen to own property and might someday need to deal with someone unwelcome, or maybe you're a tenant, or you work in a field like journalism, or even if you're just a citizen moving through public and private spaces, recognizing the boundaries defined by trespass law is pretty important.
It really is a potent reminder that permission or consent isn't always a clear sign on a fence or an explicit verbal yes. It can be implied by the situation, it can be withdrawn, and sometimes it can even be invalidated by deception. And those property boundaries, even the invisible ones, interact constantly with other rights we hold dear, like our freedom to speak or our ability to gather and share information.
Absolutely. Navigating these interactions safely and legally really requires being aware of your surroundings, understanding the cues that indicate private or restricted areas, and just recognizing that your actions can have legal consequences if they involve being on someone else's property without the proper authorization, whether that's express or implied.
This deep dive really shows that while we might have a simple gut feeling about, staying off someone else's private property, the actual legal reality of trespass is this multi-layered concept. It's constantly balancing core property rights with individual actions and even these broader constitutional freedoms.
It definitely makes you think more consciously about the invisible lines we cross every single day. the different expectations of privacy and access we encounter, and how rapidly evolving technology and, frankly, social interactions can challenge our traditional understanding of where exactly those lines are drawn.
Yeah.
It certainly raises an important question for the future. Given how technology continues to blur the lines between public and private spaces, and how easy it's become to document pretty much every interaction, will our current legal definitions of trespass and these related torts, like invasion of privacy, be sufficient? Will they need to adapt to address the kinds of conflicts that are likely to keep arising?
That is a fascinating thought to mull over until our next deep dive. Thanks for joining us.
Thanks for tuning in to the Am I Free to Go podcast. Support the show by checking out our First Amendment gear, wear your rights proudly, and help us keep creating content like this. You can also join us on Patreon for access to uncut videos, outtakes, bloopers, and exclusive audio-only episodes. Don't forget to subscribe and hit the bell across all our channels. Links are in the description, and most importantly, we love reading your comments. Drop your ideas below, and you might hear your suggestion in a future episode.